Hi there, welcome to week 7 of administrative law. This week we'll be taking a look at another ground of review. This week we're focusing on unauthorised decision making. We'll start off this video by talking about an introduction to unauthorised decision making, the sort of general principles behind it, and then we'll focus on the different types of unauthorised decisions that are provided for in the Administrative Decisions Judicial Review Act. So in particular, we've got 5. We'll focus on the first 3 in this video. The 4th one we'll take a look at in next week's lecture. And the 5th one, a decision involving an error of law, sort of cuts across multiple weeks. So our main focus in this video is the first 3, which is procedures that weren't followed, the decision maker not having jurisdiction to make a decision, and the decision not being authorised by an enactment. Let's start our discussion of unauthorised decision making by revisiting the principle of legality, which we talked about in week 6. The way the principle of legality plays out in relation to unauthorised decision making is that a decision maker must be authorised to make a decision under a piece of law, under an enactment. So it's not the case that a decision maker can do anything unless there's a law that says they can't. It's the reverse. A decision maker can't do anything, can't make a decision unless there is a specific law that authorises them to make that decision. And this was summed up by Chief Justice Camden in Entick and Carrington, where Chief Justice Camden said, "If no excuse can be found or produced, the silence of the books is an authority against the defendant and the plaintiff must have judgment." So the silence of the books, if there's no law authorising the decision, then that counts against the defendant, the decision maker, and counts in favour of the plaintiff or the applicant or the person challenging the decision. The principle of legality in relation to unauthorised decision making has also been applied in Australia or imported into Australia. Chief Justice French summarised that quite nicely when he said that it's expressed as a presumption that Parliament does not intend to interfere with common law rights and freedoms except by clear and unequivocal language for which the Parliament may be accountable to the electorate. So in order for a decision maker to be authorised to make a decision, and remembering that those decisions might interfere with people's rights, there has to be an express statement by Parliament authorising that decision. So when we talk about unauthorised decisions as being a ground of review, essentially what we're saying is that this decision was not authorised by law. There's no authority under law for the decision maker to make that decision. And there's 5 ways that the Administrative Decision Judicial Review provides for unauthorised decisions as a ground of review. The first is that the proper procedures haven't been followed. So the decision maker didn't go through the steps that were required, and as a consequence of that, the decision couldn't be said to be authorised. The second is that the decision maker didn't have jurisdiction to make the decision. So there is some problem with the authority that was given to the decision maker. The third is that the decision was not authorised by enactment. So really, that really is captured by the principle of legality that we've talked about. There's actually, you can't point to a law that says the decision maker can make this decision. The 4th point, making a decision was an improper exercise of power. We'll revisit that point in week 8 when we talk about making a decision for an improper purpose or making a decision that isn't captured by the purpose of the statute. And lastly, the decision involved an error of law. So making some mistake at law that would invalidate the decision. So we'll unpack those first 3 in a bit more detail now, and we'll start off with proper procedures not being followed, which is section 5(1)(b). In order to sort of meet this ground of review, we need to ask and answer 3 questions of ourselves. firstly, does the Act specify a procedure to be followed? So does the Act set out a procedure? Secondly, was the procedure breached, and in what way was the procedure breached? And thirdly, is it a purpose of the statute that an act done in breach of the procedure be invalid? So not all breaches of procedure will necessarily invalidate the decision. So we need to work out, based on the statute as a whole, whether failing to follow the procedure should invalidate that decision. So the first step, does the Act specify a procedure to be followed? Really, to answer that, you have to look at the Act itself, obviously, but some general types of procedures and procedural requirements that you should be alert for when reading through an enactment. The procedure could be in relation to an application. So, for example, a requirement that an application for an age pension be in writing. The procedure can be in relation to steps in the decision-making process. So does the Act spell out that the decision maker has to follow a certain procedure? Do they have to engage in consultation? Do they have to seek expert advice? Something like that. So a requirement about the decision-making process. And thirdly, does the Act spell out any post-decision steps that the decision maker has to go through? For example, providing reasons, alerting applicants to their right to appeal or review, for example. So there's a huge breadth of possible procedures that can be provided for, and you need to look at each specific Act to know what that is. But those are just some common ones to be alert to. So the second question is, well, once we've identified that procedure, did the decision maker breach that procedure? And so here, of course, we're looking at what the decision maker did or didn't do. That's going to depend on the facts of each case, obviously. And so that will be a factual matter to determine. What did the decision maker do or fail to do? And how did that relate back to the procedure? And then the last question is to look at the legal consequences of that breach. And here we can take a closer look at Project Blue Sky and the Australian Broadcasting Association, because this is a really great case that really settled the matter of, do all breaches of procedure invalidate decisions, or can you sometimes, not quite meet every step in the procedure, but the decision itself still be fine? And that was answered conclusively in Project Blue Sky, where the court said that what you have to do is look at the purpose of the statute, and is it the purpose of the statute that the act be done, that an act done in breach of procedure should invalidate the decision or not? So in that case, there's sort of three elements that made up the factual matrix. The first element was Clause 9 of the standard broadcasting conduct rules that were developed by the Australian Broadcasting Association, said that Australian broadcasters had to have 55% of programming time between 6 a.m. and midnight had to be Australian-made programs. So trying to cultivate the Australian sort of film and television industry. So Clause 9 of the standards said 55% of broadcasts in Australia have to be Australian programs. The second element was Section 160 of the second element was Section 160D of the Broadcasting Services Act, which said that the Australian Broadcasting Association had to meet or satisfy any obligations that Australia had under international treaties. So when it was coming up with its standards of conduct, it had to do so in a way that was consistent with Australia's international obligations. And then the third element was a trade agreement between Australia and New Zealand, which provided that Australians in New Zealand and New Zealanders in Australia, either people or services, had to be afforded the same rights as in the other country. And so the controversy in this case was that Clause 9, the requirement that 55% of broadcasts be Australian programs, didn't afford an equal treatment to New Zealand programs. There was no requirement that 55% of broadcasting in Australia be New Zealand programs, because, of course, you couldn't satisfy both at the same time. And so the controversy was, had the Australian Broadcasting Association breached Section 160, which said you have to satisfy international agreements, like the agreement between Australia and New Zealand, in coming up with Clause 9. And the court said, no, this didn't invalidate Clause 9. They said that Clause 9, and this is the tricky distinction, Clause 9 was unlawful, but not invalid. So Clause 9 was unlawful because it didn't meet with 160D of the Broadcasting Services Act, because it didn't fully meet Australia's international treaty obligations. But the purpose of the Broadcasting Services Act was such that a breach of 160D was not intended to invalidate a decision. And the court reached that conclusion on the basis that the Act itself was largely policy-based, and 160D was stated in more of in more aspirational terms. It was a goal to aspire to, rather than a hard rule with mandatory consequences. So the court concluded that, yes, Clause 9 of the Standards of Conduct is not consistent with the requirements of 160D, but it wasn't the purpose of 160D to invalidate decisions that didn't comply with it. And so that decision was not invalid. So Clause 9 could stand on its own, even though it didn't afford equal treatment to Australian and New Zealand broadcasters. What we can draw from that case then is that, one, the test is the purpose of the statute that an act done in breach of the procedure should invalidate the decision? And there's three possible answers to that. The first is that any breach, no matter how minor, should invalidate the action. So a mandatory procedure. It doesn't matter what you do, if you breach that, the decision will be invalid. On the other end, no breach, no matter how glaring, would ever invalidate the action. So a procedure that's only directory and the decision maker has discretion whether to follow it or not. If they choose not to follow it, it doesn't invalidate the action. And then third is sort of a middle ground where failure to substantially comply would invalidate the action. And so this is where probably we'll find ourselves a lot of the time. And so it's a question looking at the purpose of the act as a whole to determine what its purpose is and whether failure to substantially comply with the procedure should invalidate the action or not. And that's potentially where you come in at making a persuasive argument on either side about what the purpose of the statute is and whether the decision maker has substantially complied or not. The second way in which a decision might not be authorised is where the decision maker has no jurisdiction. This is not the case. When we think about jurisdiction, we typically think about, was it Commonwealth or state? Within state, was it Queensland, New South Wales, things like that? And that's not really what this is referring to. This is referring to jurisdiction in terms of, is this an area over which the decision maker has authority to decide something? And what we're really focused on here is when this is one of those limited times where a question of fact can be judicially reviewable. So You'll remember from our discussion of merits review that, as a general rule, questions of fact are taken up under merits review, and judicial review isn't usually interested in questions of fact. This is an exception. This is a time when judicial review can look at a question of fact or an error of fact, but it's only available in very specific circumstances. So you'll remember the sort of classic formulation of a law or a power is to say that if X exists, Y may do Z. So if a particular fact arises or is established, the decision maker can do a thing. There's two ways of reading that. The first way is that X must exist before Y has the power to do Z. So X must be an established fact before the decision maker can do that thing. We call this a jurisdictional fact. Y's jurisdiction hinges on the existence of X. So if you think about our example from the merits review week about dangerous dogs, if in order for the director of animal control to make a control order, the dog itself has to be a dangerous dog, and the ability to make a control order hinges on the dog being dangerous. The second way to read if X exists, Y may do Z, is that Y's jurisdiction includes deciding whether or not X exists. And this would be a non-jurisdictional fact because Y's jurisdiction isn't contingent on X existing. Instead, Y's jurisdiction includes deciding whether X or not exists. So in the director of animal control example, the director of animal control has the power to decide if a dog is dangerous or not. And so that might be, they might have some guidelines to help them make that decision. They need to have regard to whether it's attacked someone or, maybe the type of breed of dog, although it's controversial, that sort of stuff. But ultimately, it's up to the director of animal control to decide whether or not the dog is itself dangerous or not. And once they've decided that, if they decide it's dangerous, then they can make a control order. But included in their power is the power to decide whether a dog is dangerous or not. And so the difference between the two is that if the power relies on a jurisdictional fact, then an error in fact finding, so finding that the dog is dangerous when it's not, is an error of law and can be reviewed under judicial review. So if we're going under the first category, jurisdictional fact, if we can prove that the dog's not dangerous, we can get judicial review to say, well, this dog isn't dangerous, therefore the director of animal control had no authority to make that decision, to put in the control order. If we're going under the second category, if it's a non-jurisdictional fact, then an error in the fact finding, in deciding whether the dog is dangerous or not, would not be reviewable under judicial review. We can only look at it as a question of merits review because it's a decision of fact within the director of animal control's jurisdiction. The legislation states that they've got the power to decide whether the dog is dangerous or not. So the burning question then is, how do we distinguish between jurisdictional and non-jurisdictional facts? How do we know that a particular power gives the decision maker the power to decide whether X exists or not? And the way that we distinguish between the two and determine between the two is to look at the legislation itself. And as a general rule, if the language is expressed in terms of where X exists or when X exists or if X exists, that would tell us that it's a jurisdictional fact. The X's existence is completely separate from the decision maker's power. On the other hand, if the language is where in the opinion of the minister, or in the opinion of why X exists, or if in the opinion of why X exists, that would indicate to us that this is a non-jurisdictional fact, because the legislation is actually saying the minister, the director of animal control, whoever it is, the decision maker, their opinion about X's existence is what matters, not whether X objectively exists or not. So that's a really important distinction. So it's important that you're clear on that, and we can spend more time in the tutorials talking about that if that's still something that you need a bit more help with. But the distinction is, look to the language of the legislation. If X's existence, if the particular sort of precondition is worded in a way that's sort of a bit more objective, then it's probably going to be a jurisdictional fact, and we can review it if we can show that X does not in fact exist, or whatever it is. If the legislation is worded in a way that it's a bit more subjective, if the decision maker is given the authority or the jurisdiction to decide whether X exists or not, that's going to be non-jurisdictional. We can't get judicial review of that decision because the decision is authorized by the minister making that determination, yes or no. So that's the distinction between those two, and that's one of those rare cases where judicial review might be available for an error of fact. To highlight that with a real-world case, and this one's a bit technical, but I also think it's a nice, clear example. So we'll go through it in a bit of detail and quite carefully. In Paul and Monday, we had the Health Act of 1935, which said that the Governor in Council can make regulations for or with respect to regulating, controlling, and prohibiting the emission of impurities from fuel burning equipment or any air impurity source. So Health Act 1935 gives the power to regulate air impurities. Under the authority of that act, the Governor in Council made the Clean Air Regulations of 1969 and directed that no person shall light, maintain, or permit to burn any open fire on any land or premises without written approval of the local Board of Health. So in order to regulate sources of air impurity, in this case, open air fires, they said you need to have a permit to have that open air fire. The difficulty with that is that the subject matter of the power from the Health Act was the emission of air impurities. So the decision maker was empowered to make regulations with respect to the emission of air impurities. The subject matter of the regulation was open fires, which is not the same thing. And where it gets a little bit kind of tricky is that, of course, an open air fire is going to emit air impurities in the form of smoke, but they're not exactly the same thing. And therefore, the regulation was actually invalid because it was not authorized by the Health Act. What they should have done instead was, in the regulation, say, if you're going to, do anything that is going to emit an air impurity like smoke, you need a permit from the local health board. So focusing on the air impurities rather than the source of the air impurity, which is the fire. And so Chief Justice Gibbs, in that case, sort of summed up the position by saying that where a statute allows certain means to be adopted, it does not permit the adoption of different means which happen to lead to the same end. So, of course, regulating open fires would have addressed the emission of air impurities, but because they weren't exactly the same thing, the regulation was not authorized, and therefore the decision maker had no authority to make that regulation. So a very, very technical difference, but one that I think quite clearly highlights just how important it is to be really careful about identifying what's the subject matter of the power and what's the subject matter of the regulation, or what's the content of the decision, and do those two things match up or not. And if they don't, then it's probably not going to be an authorized decision, and the decision maker will have had no jurisdiction to make that decision or make that regulation. We'll leave it there. As I said, we'll talk about the making of a decision being an improper exercise of power in next week's lecture, because that goes to the purpose of the law, and that's going to be a big topic that we'll be discussing in the week 8 videos. So we will call it there. Thanks very much for watching. And as I said, we'll go through some more examples of the distinctions between these different types of law in the tutorials to help you really unpack the differences between them. So we'll see you then.